Good afternoon. This is Joe Hall, and I'm continuing to celebrate Black history by going and spending quite a bit of time with the entire month, with the Equal Justice Initiative. I'm reading the piece that they wrote, Lynching in America. We're on chapter 5, Confronting Lynching. Martin Luther King being booked in a Montgomery jail in 1958 for civil rights activism, and that's Montgomery, Alabama. Of course, Montgomery, Alabama being the place where the Montgomery bus boycott started in December of 1955 and ended in 1956 with the desegregation of the buses, the beginning of the civil rights movement in terms of success. Of course, many people say that the civil rights movement began on August the 28th, 1955, with the lynching of Emmett Till. When the era of racial terror and widespread lynching ended in the mid-20th century, it left behind a nation and a Southern South fundamentally altered by decades of systemic community-based violence against Black Americans. The effects of the lynching era echoed through the latter half of the 20th century. African Americans continued to face violent intimidation when they transgressed social boundaries or asserted their civil rights. And the criminal justice system continued to target people of color and victimize African Americans. These legacies have yet to be confronted. Violent intimidation in opposition to equality. After the rate of lynchings abated, the central feature of the era of racial terror, violence against Black Americans, took new forms. The social forces and racial animus that made lynching a frequent occurrence and constant threat in the late 19th and early 20th centuries remained deeply rooted in the American culture, and violent intimidation continued to be used to preserve social control and white supremacy. African Americans in the South continued to face violence, threats, and intimidation in myriad areas of daily life with no protection from the justice system. Black Southerners who survived the lynching era remained subject to the established legal system of racial apartheid known as Jim Crow. As organized resistance to this racial caste system began to swell in the early 1950s, Black demonstrators were met with violent opposition from white police officers and community members. Black activists protesting racial segregation and defranchisement through boycotts, sit-ins, voter registration drives, and mass marches consistently faced physical attacks, riots, and bombings from whites. The leader of a nonviolent protest movement, the Reverend Dr. Martin Luther King Jr., challenged white law enforcement officials and private citizens who issued death threats, physically assaulted him at public lectures, and bombed his Montgomery, Alabama home while his wife and infant daughter were inside. Police attacked demonstrators during a highly publicized events like Bloody Sunday in Selma, Alabama in March of 1965. Even Black children engaging in peaceful demonstrations were at great risk of harm and death. Remember that Dr. King in Birmingham, Alabama put forth the children of the Black adults as the demonstrators to show America just how violent and how disgraceful white Southerners were. In 1963, September 15th, 4 young girls were killed when the 16th Street Baptist Church in Birmingham, Alabama was bombed. And in that year, more than 700 Black children protesting racial segregation in the city were arrested, blasted with water hoses, clubbed by police, and attacked by police dogs. And of course, on June 12, 1963, Medgar Evers was murdered by Byron D. LeBeckworth in the driveway of his home in front of his wife and children. Closely mirroring the era of lynching, police in Mississippi facilitated the extrajudicial murder of civil rights workers Andrew Goodman, James Chaney, and Michael Schwerner in 1964 by delivering the men to a white mob after detaining them in an alleged traffic violation. A mob of Ku Klux Klanmen who had gathered during the several hours the three young men were held in jail were ready and waiting to seize and murder them upon release. Just as the lynchings had been justified in the preceding decades, these violent incidents were defended as necessary to maintain law and order. Sheridan, Arkansas. On Tuesday, October 6, 1903, a mob of masked men took Ed McCullum, a black citizen of Grant County, Arkansas, from the county jail in Sheridan. The men tied him to a tree on the lawn of the county courthouse in the town's center square and shot him to death, leaving his body riddled with bullets. Mr. McCullum had been in the county jail since the previous Saturday for wounding a local constable during an arrest. Newspaper coverage of the lynching was terse and matter-of-fact, a reflection of how common such extrajudicial killings of African Americans had become during this time in this region. The town of Sheridan remained a hostile environment for African Americans in the following decades, but some found work at the local sawmill and built a small, resilient black community. In May of 1954, 4 days after, and it would be May 21st, 4 days after the United States Supreme Court ruling in Brown versus the Board of Education banning racial segregation in public schools, Sheridan School Board unanimously voted to integrate its junior high and high schools. Under the vote, 21 black students would join 600 white students in upper school that fall and were guaranteed a discrimination-free experience in athletics, cafeteria service, and school dances. Young black children will continue to attend the local two-room segregated lower school. The district's swift moves towards integration, which made Sheridan the first community in the South to take action after Brown, was likely influenced by the fact that the town was spending nearly $5,000 per year to maintain segregation by busing black high school students to a segregated school 25 miles away. Just one day after the school board's historic vote, hundreds of Sheridan white residents organized a protest meeting in the high school gymnasium. In response, the school board unanimously rescinded its integration resolution, citing a sincere desire to be the representatives of our patrons in school matters. Unsatisfied, several hundred white citizens circulated a petition calling for the resignation of the entire school board. All but one member ultimately stepped down. Jack Williams, owner of the local sawmill and landlord for most of its employees, then approached black families living on his property and demanded that they let him move their wooden shack homes to Melbourne, 20 miles to the west, or he would evict them and burn their houses to the ground. Of course, the black sawmill workers moved to Melbourne, and much of Sheridan's black community followed. Of course, what happened to Sheridan was Sheridan then in turn became a sundown town. Recently, James Seawood, a black man who attended Sheridan's segregated elementary school as a child, recalled marveling at the white school's huge building, marching band, and football team from atop the sawmill's lumber stacks before returning to his own two-room school with 2 teachers and outdoor toilets. Mr. Seawood's mother was the last black teacher in Sheridan. Just before they left town, they watched the bulldozer dig a large hole and push the entire school into the ground and cover it up, wiping out all evidence of its existence. Much of Sheridan's racial history of lynching, segregation, violent intimidation has also been buried, as much of black America history is buried in white America. The town, just like we talked about on the Black Man's Read Aloud Hour, the difference between the White Lion ship and the Mayflower ship. The town remained completely white for decades, and its public schools did not desegregate until 1992, when the school districts of two small interracial communities nearby consolidated with the larger district. Even then, Sheridan's white parents and students yelled racial epithets during the high school sporting events against interracial teams. In 2014, less than 2% of the town's residents were African American. Racially biased criminal justice and mass criminalization, lynching and racial terror profoundly compromised the criminal justice system. Extrajudicial mob violence operated hand in hand with the legal execution as a means of exercising lethal social control over the black population. Neither lynching nor legal executions required reliable findings of guilt, and complicit law enforcement officers handed over prisoners to the lynch mobs. Southern courts were deeply embedded in the exploitation of black workers in the South long after the formal abolition of slavery. States exploited the 13th Amendment's exemption for prisoners by passing black codes and convict leasing laws that branded black people as criminals to facilitate their re-enslavement for state profit. Further, although the Civil Rights Act of 1875 and the Supreme Court rulings banned racial discrimination in jury selection, local officials barred African Americans from serving on juries. African Americans virtually disappeared from the Southern jury box by 1900, even in counties where they constituted an overwhelming majority of the local population, which reinforced the impunity under which lynching flourished. The fairness of the judicial system was wholly compromised for African Americans, and the courts operated as tools of their subjugation. Of course, one of the books that we read on the Black Man Read Aloud Hour is They Call Me Lightning, the story of Mr. Washington, who had been placed on death row for a crime he didn't commit and escaped death 19 times. Lynching also fostered directly the racialization of criminality. Whites defended vigilante violence aimed at black people as a necessary tactic of self-preservation to protect property, families, and the Southern way of life from dangerous black criminals. The link between lynching and the image of African Americans as criminal and dangerous was sometimes explicit, such as when lynchings occurred in response to allegations of criminal behavior. In other cases, white mobs justified the lynching as a preemptive strike against the threat of black violent crime. Decades of racial terror in the American South reflected and reinforced the view that African Americans were dangerous criminals who posed a threat to innocent white citizens. Although the Constitution's presumption of innocence is the bedrock principle of American criminal justice, African Americans were assigned a presumption of guilt. America has never addressed the effects of racial violence, the criminalization of African Americans, and the critical role these phenomena have played in shaping the American criminal justice system, particularly in the South. The Civil Rights Act of 1964, a signature legal achievement of the civil rights movement, contains provisions designed to eliminate discrimination in voting, education, and employment, but it does not address discrimination in criminal justice. Though the most insidious tool of racial subordination throughout the era of racial terror and its aftermath, the criminal justice system remains the institution in American life least impacted by the civil rights movement. Similarly, the system's endorsement of racist myths of black criminality has never been meaningfully confronted. The unprecedented level of mass incarceration in America today is a contemporary manifestation of these past distortions and abuses that continue to limit the opportunities of our nation's most vulnerable. Lynching's legacy, capital punishment in America. Perhaps the most important reason that lynching declined is what it was replaced by, a more palatable form of violence. As early as the 1920s, lynchings were disfavored because of the bad press they garnered. Southern legislators shifted to capital punishment so legal and ostensibly unbiased court proceedings could serve the same purpose as vigilante violence, satisfying the lust for revenge. And as I read many times on the Black Man's Read Aloud Hour, many cases of unjustified penalties of death were placed against African Americans, and Thurgood Marshall said that when you went to appeal many of these cases, not to get the case overthrown or dismissed, but just simply to get the black man, the black prisoner or the black convict, the innocent convict, to have his sentence reduced to life was a victory. The most infamous attempted legal lynching likely is that of the so-called Scottsboro Boys, 9 young African Americans charged with raping 2 white women in Scottsboro, Alabama in 1931. White mobs converged outside the courtroom during the trial to demand that the accused be executed. I've actually visited that courtroom or that courthouse in Scottsboro, Alabama. Represented by incompetent lawyers, the 9 were convicted by an all-white, all-male jury within 2 days, and all but the youngest was sentenced to death. When the NAACP and others launched a national movement to challenge the cursory proceedings, the white people in Scottsboro did not understand the reaction. After all, they did not lynch the accused, they gave them the trial. Many defendants of the era learned that being sentenced to death rather than lynched did little to increase the fairness of the trial, the reliability of the conviction, or the justness of the sentence. Northern states had abolished public executions by 1850, but some southern states authorized the practice until 1938. Public hangings were often racialized displays intended to deter mob lynchings more than individual crimes. Following Will Mack's execution by public hanging in Brandon, Mississippi in 1909, the Brandon News reasoned that the public hangings are wrong, but under the circumstances, a quiet acquiescence of the people to submit to a legal trial and their good behavior throughout left no alternative to the Board of Supervisors but to grant the almost universal demand for a public execution. Mobs often succeeded in forcing a public hanging in southern states where the practice was illegal. In Somerville, Florida in 1902, a black man named Henry Wilson was convicted of murder in a trial that lasted just 2 hours and 40 minutes. To mollify the mob of armed whites that filled the courtroom, the judge promised the death sentence would be carried out by public hanging despite a Florida law prohibiting public executions. Even so, when the execution was set for a later date, the enraged mob threatened, "We'll hang him before sundown, governor or no governor." Florida officials quickly moved up the date, authorized Mr. Wilson to be hanged before a jeering mob, and congratulated themselves on the avoided lynching. By 1915, court-ordered executions outpaced lynchings in the former slave states for the first time. 2/3 of those executed in the 1930s were black, and the trend continued as African Americans fell to just 22% of the South's population between 1910 and 1950. They constituted 75% of those executed in the South during that period. In the 1940s and 1950s, the NAACP's Legal Defense Fund, the LDF, began a multi-decade litigation strategy to challenge the American death penalty, which was the most active in the South as racially biased and unconstitutional. They won in Thurman versus Georgia in 1972 when the United Supreme Court struck down Georgia's death penalty statute, holding that the capital punishment too closely resembled self-help, vigilante justice, and lynch law, and that if any basis can be discerned for the selection of these few to be sentenced to die, it is the constitutionally impermissible basis of race. Southern opponents decried the decision and immediately proposed new death penalty statutes. In 1976, in Gregg versus Georgia, the Supreme Court upheld Georgia's new death penalty statute and reinstated the American death penalty, capitulating to the claim that legal executions were needed to prevent vigilante violence. The new death penalty statutes continued to result in racial imbalance and constitutional challenges persisted. In the 1987 case of McCleskey versus Kemp, the Supreme Court considered statistical evidence demonstrating that Georgia's decision makers are more than 4 times as likely to impose death for the killing of a white person than a black person. Accepting the data as accurate, the Supreme Court described racial bias in the sentences as an inevitable part of our criminal justice system and upheld Warren McCluskey's death sentence because he had failed to identify constitutionally significant risk of racial biases. In his case, race remains a significant factor in capital sentencing. African Americans make up less than 13% of the nation's population, but nearly 42% of those currently on death row in America are black, and 34% of those executed since 1976 have been black. In 96% of the states where researchers have completed studies examining the relationship between race and the death penalty, results reveal a pattern of discrimination based on the race of the victim, the race of the defendant, or both. Capital trials today remain proceedings with little racial diversity. The accused is often the only person of color in the courtroom, and illegal racial discrimination and jury selection is widespread, especially in the South and in capital cases. In Houston County, Alabama, prosecutors have excluded 80% of qualified African Americans from juries in death penalty cases. More than 8 in 10 American lynchings between 1889 and 1918 occurred in the South, and more than 8 in the 10 of the nearly 1,400 legal executions carried out in this country since 1976 have been in the South. Modern death sentences are disproportionately meted out to African Americans accused of crimes against white victims. Efforts to combat racial bias and create federal protection against racial bias in the administration of the death penalty remain thralled by familiar appeals to the rhetoric of states' rights. And the regional data demonstrates that the modern death penalty in America mirrors racial violence of the past. As contemporary proponents of the American death penalty focus on form rather than substance by tinkering with the aesthetics of legal punishment to improve procedure and methods, capital punishment remains rooted in racial terror, a direct descendant of lynching. And that is the end of the reading for tonight of Chapter 5. Chapter 5, Confronting Lynching. Tomorrow we will be reading Chapter 6, Trauma and the Legacy of Lynching, as I continue to salute during Black History Month the Equal Justice Initiative's work on lynching in America. Have a great day.